Okay, here's the deal. The Bill of Rights, the first 10 amendments of the US Constitution, isn't just some old useless list that we can probably do away with.
Hell yes, we're gonna take your AR-15, your AK-47.
It's a foundational text with an 800-year history going back all the way to the Magna Carta that recognizes the free rights of man, the rule of law, and the necessary restrictions on government to defend against tyranny. I'm Jake the Lawyer, and welcome back to Internet Esquire. Unfortunately, today in America, we tend to gloss over the Bill of Rights as either something just suggested or something at best that a few wise old men came up with a really long time ago. In reality, it is nothing short of remarkable, a continuance of basic concepts of individual freedoms and liberties dating back 800 years that is still also legally and culturally essential to modern American life. In fact, most people don't know this, but the Bill of Rights made the Constitution possible, and therefore modern America along with it. Now, if you already find this interesting, make sure you subscribe, because next week I'm going to be doing a full breakdown on all 10 amendments of the Bill of Rights in simple terms that anybody can understand. Until then, let's explore exactly why the Bill of Rights made America possible, getting into the history and the drama that gave rise to its existence. Okay, most people don't know this either, but the Constitutional Convention of 1787 did not initially meet to draft a new constitution. At first, they met to amend the Articles of Confederation, which were the governing documents of the national government of the day. But obviously, we know from history that's not what happened during the convention. Soon after they met, the framers began drafting a new constitution, and they threw out the Articles of Confederation. The goal of the new constitution was to create a stronger central government, although still limited in power, and it contained no Bill of Rights. And by September 1787, the final draft of the Constitution was done, it was signed, but it was still not law yet. You see, it needed ratification of 9 out of the original 13 states in order to actually be operative. Two groups immediately formed, Federalists and Anti-Federalists. Federalists supported the new constitution and wrote the Federalist Papers to try and persuade public opinion that the new government was a strong but limited federal government. They argued that a Bill of Rights was not necessary to the Constitution because the Constitution inherently limited the amount of power that the central government could have. These main Federalists, Alexander Hamilton, James Madison, and John Jay, had an argument something like this. The federal government can only do what we specifically give it the power to do. So if we didn't give it the power to violate rights, why should we list those rights? But the Anti-Federalists had an entirely different view. If you create a powerful national government and do not explicitly spell out what it cannot do, it will eventually do those things. Now, with the advantage of history behind us, we can say that it's rather weird because even when you do explicitly spell things out, it still might do or try to do the things that you say it cannot do. It's just one of those things. Anyway, this anti-federalist position wasn't completely unfounded. In fact, it was well-founded. They had just gotten done fighting a war for 9 years against the British Crown as a result of British tyranny. So the anti-federalists insisted that a Bill of Rights be added to the Constitution because they didn't trust any government, especially one that was located hundreds of miles away from the people that it governed. They wanted explicit protections of individual rights and did not support ratification of the Constitution unless a Bill of Rights was added, and they wrote the Anti-Federalist Papers to persuade public opinion to their point of view. So when the final draft of the Constitution began going out between late 1787 and mid-1788 to all of the states for ratification, the Federalists and Anti-Federalists duked it out over these matters. Via essay, of course. Now, during this period, there were 5 states to ratify early without any amendments. North Carolina and Rhode Island, however, refused to ratify at all until a Bill of Rights could be added to the Constitution. And then came the Massachusetts Compromise, where the state of Massachusetts, alongside Virginia and New York, 2 other huge states of the day, said, "We'll agree to ratify the Constitution if you agree to immediately add a Bill of Rights right away." This compromise eventually allowed for final ratification of the Constitution in June of 1788, and it did not yet have a Bill of Rights. But ratification was just the first step. While it did make the Constitution legally operative, it did not make it politically final. This would not come until the Bill of Rights was added, which was promised in the Massachusetts Compromise. So when the first new federal government began meeting in March of 1789, James Madison, a staunch Federalist, took up the issue of crafting a Bill of Rights and having it ratified as the first 10 amendments to the Constitution. Now you might say, Madison, that's a little weird. He was a Federalist. Now why would he go ahead and try to add a Bill of Rights to the Constitution if, as a Federalist, he was probably against that? Well, Madison realized that although the Constitution was legally operative at that time, it was not going to be politically legitimate until that Bill of Rights was added. The reason for this is pretty simple. A lot of times today, people think that the federal government is just this huge thing that can sort of do whenever it wants, but this was not true at the beginning when the Constitution was ratified. In fact, the federal government was like a newborn baby, stumbling around. The individual states could have easily killed not just the Constitution and the new federal government, but the entire Union itself if they didn't politically like what it had to offer. States like Virginia, Massachusetts, and New York alone were way more powerful than the new central government. Maybe it should still be like that. Federal Housing Association, the Department of Homeland Security. Getting these key states to agree, both legally but also politically, was absolutely critical to the entire thing. So in September of 1789, Madison got to work, adding a total of 19 original amendments to the new US Congress at the time, and then they got to work, either condensing or cutting them down into what would become the actual 10 amendments in the Bill of Rights. But there was one more hurdle that had to be jumped over before the Bill of Rights could be added. To amend the Constitution required a 3/4 ratification by all of the states, and as Vermont was now being added as the 14th state, the burden of how many states had to ratify went from 10 to 11. So by late 1791, with 10 states having ratified the new Bill of Rights, Congress needed one more. And while any one of the remaining states could have ratified the Bill of Rights, that would not have made the new amendments politically binding, and therefore the Constitution itself politically binding. They needed Virginia, one of, if not the leading state of the day. This finally happened on December 15th, 1791. The 3/4 majority requirement was met, and the new Bill of Rights was born. And thanks to the Anti-Federalists and the states who demanded that a Bill of Rights be added, there were now constitutional safeguards protecting individual liberties in this new federal system, which is great. But the history of how we got to those rights has its own fascinating origins. The intellectual inspiration for the American Bill of Rights was George Mason, a founding father of the time who also wrote the Virginia Declaration of Rights. These rights were then picked up by James Madison when he went to make the original proposals, but both Mason and Madison didn't get these ideas out of nowhere. In drafting these rights, they were pulling upon an 800-year history dating back to concepts first established in the Magna Carta. The Magna Carta of 1215 AD. That's Anno Domini.
Us Latin, doll. Evidently, Mr. Ringo's an educated man.
We don't say CE on this channel. We say Anno Domini, which means the year of our Lord, because Jesus Christ is Lord. CE. We're just gonna say CE because, like, AD could be offensive to some people. Get that trash out of here. Okay, let's start at the beginning. In medieval England, where a group of angry barons got so mad at their king that they raised their own armies, marched to London, and demanded some gosh dang respect. In 1215, King John of England was broke, unpopular, and terrible with money. The English barons, who were basically the upper-class landowners of the time that actually ran John's kingdom for him, had had enough. You see, John was demanding huge sums of money from the barons in order to fund his wars, which he was then losing, and in 1204, for example, he had lost most of England's claims within France, and after losing those wars, turned around and blamed it on the barons and then just demanded more money from them. But it wasn't just about the money. John was notorious for seizing property without cause, imprisoning people he didn't like, selling justice to the highest bidder, and ignoring the traditional rights of the noble class that actually ran his kingdom. So finally, after enough years of tyranny from good old John Boy, the barons got together and with their own armies forced him to bargain. The outcome of this negotiation was the Magna Carta, which is otherwise known as just the Great Charter, or more directly, the Great Paper. The Great Paper. Do you remember the Great Paper, sir, of 1215? Ah, yes, I remember the Great Paper. Do you know how damn expensive paper was back then? I had to sell 2 horses just to write my daughter a birthday card. Now, to be clear, the Magna Carta wasn't some magical document that created a constitutional republic or the right to vote or recognized that all men are created equal. No, it was very simple. Specifically, there were 2 revolutionary ideas that did not exist beforehand. The first one was the idea of the rule of law, and the second one was the idea that there are certain rights which belong to the people which cannot be taken away by anybody, even the king. In its most basic form, the Magna Carta explicitly stated that the king's power had limitations, that those had enforceable limitations, and if he went beyond those limitations, his power could be taken away from him. This sounds obvious to us today, but at the time, it was a relatively shocking legal development. This was the first time where the rule of law stood above a king, and now even the king himself was a subject of the law. The second thing was the people's rights. The basic idea that the people, at least the free people who were the barons alongside King John, had certain rights that could not be taken away by the government. And this is where we begin to see the essence of our own Bill of Rights come to shape. The Magna Carta established the earliest written frameworks in the following areas. Due process of law. It stated specifically, no free man can be imprisoned, dispossessed, exiled, or killed except by lawful judgment or the law of the land. This is obviously the legal ancestor to due process, but it's also the legal ancestor to concepts like habeas corpus and the right to a fair trial. And this was a huge revolutionary step in a world where kings could just jail people for whatever reason. Taxation would require consent. The Magna Carta established that the king could not raise taxes without the consent of these other nobles. This is the legal ancestor to no taxation without representation. Property rights were protected. The Magna Carta asserted that the king could not arbitrarily seize property, the legal ancestor to no unwarranted searches and seizures, and the protection of general property rights. It also said the church is free from royal interference. Kings could not appoint bishops or give dictates to the church, and obviously this is the legal ancestor to the Establishment Clause and the Free Exercise Clause of the First Amendment. It also had an interesting thing called an enforcement council. This enforcement council was a council of 25 barons who were empowered with the ability of monitoring the king and could legally seize his property if he decided to break with the charter. In part, this is the ancestor to parliamentary and congressional approvals. And while there had been other charters and agreements signed by kings before the Magna Carta is distinct because it not only established individual liberties, but it also made those individual liberties enforceable. It made the king not subject to his own reasons and laws. It made him subject to the laws of a nation, and for the first time, it put the rule of law above the king. Also, I'm pretty sure since the barons had already gotten together, drove to London, and forced King John to the bargaining table, I'm pretty sure that if he didn't agree to any of this, well, they probably would have just killed him and then installed a new king amongst themselves who would have agreed to it. So, you know, I think it worked out pretty well for him, to be honest. Okay, fast forward 400 years, and this is where things start to get interesting. You have our great-grandfather, the Magna Carta over here, but now imagine this. Let me tell you a little story. Imagine it's the year 1628 and you are King Charles I of England. Well, enough time has gone by where you've sort of forgotten about the parameters of that dusty old charter, and so you decide to try a couple things without the consent of, Parliament. Things like levying taxes without parliamentary approval, quartering soldiers in the homes of your civilians, and other things like light things, imprisoning people just because you don't like them without any criminal charges at all. So you start doing this for a few years and your parliament starts to get a little itchy, you know, they get a little nervous. So here's what they do. They draft what's called the Petition of Right, and they bring this to you for the redress of grievances. In English, that means like, hey, can you please stop doing what you're doing? Formally. It demanded no taxation without parliamentary approval, no arbitrary imprisonment, no quartering of soldiers in people's homes, and no martial law in peacetime, meaning that you cannot use a standing army during peacetime to enforce civil law without parliamentary approval. So as King Charles I, they kind of got you by the short hairs a little bit, and so you agree to sign the Petition of Right. But you don't agree to sign it because you actually agree with them. Being the tyrant that you are, you sign it because you just want them to go away. Charles I signed the Petition of Right and then immediately ignored it, and then a year later went even further. He just disbanded Parliament.
It's a bold strategy, Cotton. Let's see if it pays off for him.
Can you guess what happened next? Well, he cast the entire kingdom into chaos for the next 60 years. First, Charles ruled without a parliament as an absolute tyrant for 11 years in what is literally known as the 11 Years' Tyranny. The English aren't that creative with names, but they certainly do tell you exactly what happened. His name is John Shoemaker. His name is John, and he's a shoemaker. I don't know what's confusing about that. Well, after enough years of tyranny, the former members of parliament raised their own standing army. And of course, when Charles saw this, well, he raised a standing army of his own. And then the English Civil War kicked off in 1642. And well, this ended with the execution of Charles in 1649. I don't know why it took 7 years for them to cut his head off, but that's how long it took. This, unfortunately, was not the end of the turmoil. After killing Charles I, the English Parliament was then reinstated, and there was a very short-lived Commonwealth period, where there was actually a republic and they did away with the monarchy. But like many young republics without constitutional safeguards to protect not only the form of government, but also individual liberties, it quickly fell into military despotism. And a man named Oliver Cromwell rose to power. In 1653, Cromwell took over and once again disbanded Parliament, reforming the government into what was known as the Protectorate, naming himself as Lord Protectorate, which, why do dictators always have the cringiest names? I am not a king, I will not call myself a king. I took over with the military and now I am Lord Protectorate of the realm, Sir Oliver Cromwell. This is just so bad. Well, this little dictatorship didn't last for very long, and eventually Cromwell died and his son tried to take over, but his son was weak, and eventually this leads to King James II. That's right, they reinstated the monarchy, and, well, who took over? One of Charles I's sons. The problem was that James II was much like his old man. He suspended laws, did things without the approval of Parliament, he tried to pack the government with loyalists, and then he also tried to raise his own standing army in peacetime. So, fearing another absolute monarchy and another 60 years of chaotic hell, the Parliament did something dramatic. They went to William of Orange and his wife Mary, who was the eldest daughter of James himself, and they said, hey, do you guys want to come down here and, well, just invade? Yeah, and then you can get rid of James and you two will become king and queen. Well, William and Mary agreed to this, and this was known as the Glorious Revolution. Once again, not super creative, but definitely on point. And well, the Glorious Revolution helped bring the chaos which began with Charles I and the Petition of Right to an end. Parliament had wised up. Before William and Mary took over, they added a few conditions.
Provisos? You mean limitations? On wishes?
Namely, the English Bill of Rights in 1689, the grandfather of the American Bill of Rights. Unwilling to repeat the mistakes that led to Lord Protector Cromwell, Parliament wrote down in no uncertain terms exactly what was expected of William and Mary before they took over. And looking at the text of the English Bill of Rights, you can easily see the influence it had on our own Bill of Rights. It had things like freedom of speech. Quote, the freedom of speech and debates or proceedings in Parliament ought not to be impeached or questioned in any court or place out of Parliament. Well, this freedom of speech was limited to things said within the Parliament. It was a huge step in saying, hey, we're gonna be able to say whatever we need to say because that's the best way to run a country. It had the right to petition government. Quote, that it is the right of the subjects to petition the king, and all commitments and prosecutions for such petitioning are illegal. Meaning, if we come to you and we have a matter that we want to solve, you can't punish us for doing so. It also had the right to bear arms. Quote, the subjects which are Protestants may have arms for their defense suitable to their conditions and as allowed by law. Now, this bit about Protestants is funny because they had just got done fighting James II, who was Catholic, and given that they had to raise an army against him in order to get the country back, I can see why they were a little hesitant about giving Catholics guns at the time. I mean, hell, look at Boston today.
Put your hands in the
It also had no cruel and unusual punishments. Quote, that excessive bail ought not to be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. As you can see, the resemblance to our own Bill of Rights is much, much stronger in the English Bill of Rights than it was in the Magna Carta. And this brings us back to our earlier point. When George Mason sat down to write the Virginia Declaration of Rights, and then later James Madison took that influence and drafted what would become our Bill of Rights, they weren't just coming up with these things out of thin air. They were looking back through history, seeing how tyranny had led to war, and how war had led to revolution, and how revolution had led to an explicit list of demands that the government shall not violate. And having lived through that most recent version of history during the American Revolution, I'm sure that the founding fathers looked around at each other and said, hey, these are a pretty good idea. Now, an interesting point. In history, we often look back at the American Revolution and just sort of meld it together with the drafting of the Constitution, but in reality, there was a few very important things that happened between the Revolution and the Constitution. Specifically, state sovereignty. Prior to the US Constitution, the states had their own state constitutions and their own bills of rights that were supreme to the authority of the central government. The Articles of Confederation, which were the governing documents for the central government after the Revolution and before the Constitution, can confirm this. And this is fundamentally different from how things work today. You see, after the Revolutionary War kicked off in 1775, the idea was that after things cooled down and the war was over, the United States of America would be, well, exactly that. A union of sovereign, free, and independent states where central government authority was derivative of state authority, not supreme to it. And under the Articles, each state kept its own powers, they could print their own money, they could even levy tariffs against other states, and in general just ran their own little country. Well, they couldn't raise armies and the central government could. The problem with that was that if the central government wanted to raise an army, they had to go to the states and request men and money in order to do so. And each state could choose how much men and money it wanted to give. They had to do it under what was called a requisition. If they needed tax money, for example, they had to go out to the states and say, hey, we're looking to raise this much money. And then the state could choose whether or not it wanted to give some, all, or none of whatever the thing requested was. Beautiful. Maybe we should get back to that a little bit, just tiny little itty bit. Under this system, the national government was so deliberately weak that it had almost no authority at all. So under this system, who was responsible to protect individual rights? Well, the states. This is why when the revolution began, the states immediately began drafting their own constitutions with their own bills of rights. In fact, well, the US Constitution is the oldest written national constitution still in use today. The oldest written constitution still in use today is that of the state of Massachusetts, written in 1780.
The spirit of Massachusetts is the spirit of America, the spirit of what's old and what's new.
So here are some examples of what these early bills of rights said in these early state constitutions. The Virginia Declaration of Rights, which we know from earlier was written by George Mason, had things like this in it. It declared that all men are by nature equally free. It protected freedoms of the press, jury trials, and property rights. And it limited searches and seizures. The Pennsylvania Constitution, written in 1776, is one of my personal favorites just because they sort of just frankly tell you exactly what they want. Here's a few examples of what theirs said. Natural rights. All men are born equally free and independent and have inalienable rights, including life, liberty, property, and pursuing happiness and safety. Freedom of religion. All men have a natural and unalienable right to worship Almighty God according to the dictates of their own consciences, and no man can be compelled to attend any religious worship. Freedom of speech. People have a right to freedom of speech, of writing, and of publishing their sentiments. Therefore, freedom of the press shall not be restrained. The right to bear arms. People have a right to bear arms for the defense of themselves and the state. How did we mess that up? Freedom of assembly. People have a right to assemble, to consult for their common good, to instruct their representatives, and petition the legislature for the redress of grievances. The cool thing about the Pennsylvania Constitution is that it paired the things it listed in the Bill of Rights with the plan and framework of the government itself. For example, the right to bear arms also required that the freemen of this commonwealth and their sons shall be trained and armed for its defense. The freedom of assembly required that the doors of the House of Representatives be open to all people, at least all people who behave decently, anyway. They also had term limits for Congress, saying that no person could serve in Congress for more than 4 out of every 7 years. Even that would help. Run by a bunch of dead geriatrics on pharmaceuticals. Oh my God. And other states such as Maryland, North Carolina, New Hampshire, and Massachusetts also had their own written constitutions with their own bills of rights and similar written protections to varying degrees. You see, the problem under the Articles of Confederation is that, while it did create a semblance of a central government, that central government was almost too weak. That all changed with the Constitutional Convention of 1787 and the introduction of a US Constitution that in the document said it was going to be the new supreme law of the land. But let's take a little pause here. At the time, states were still responsible to protect individual liberties. If the new Constitution is now the supreme law of the land, how could the states guarantee protection of individual rights to their citizens? Well, the Federalists argued that the Constitution is an inherently limited document, meaning that it only gives away the express powers that are written down in it. This wasn't quite good enough for the Anti-Federalists, and they said, hey guys, look, we have 800 years of history here to tell us that if we don't expressly state what the government cannot touch, it is eventually going to try to touch those things, and we do not want that to happen. So with the Massachusetts Compromise and now the new federal Congress, James Madison got to work to actually bring this compromise in the form of the Bill of Rights as the first 10 amendments to the Constitution. And in doing so, he drew upon these state constitutions, which would have been very familiar language to the founding fathers of the time. And eventually this worked. It was both the legal and political compromise that was needed to ensure that the new federal government would also protect individual rights in the same way that the state constitutions had done before it. And finally, with enough time and enough debates between the Federalists and the Anti-Federalists, they were able to use compromise to their advantage and add the Bill of Rights to the Constitution, politically and legally binding a new federal system together. Now, don't get me wrong, there is a huge amount of legal history and doctrine that we need to go over after the period of the Bill of Rights being ratified. But for now, that is the fascinating history of how the US Bill of Rights came to be, the 800-year history it drew upon for its language and its context, and of course, how it helped make the Constitution possible, which makes modern America possible. So if you liked this video, again, please consider subscribing, because next week I will be doing a breakdown of all 10 amendments of the Bill of Rights in simple terms that anybody can understand. Well, hopefully anybody can understand. I'll try to do my best to keep it simple. But anyways, thank you for watching. Thank you for recommending this series of videos to me in the comments. If you have other video recommendations that you would like to see me do, let me know in the comments below. And that's it. I'll see you on the next one. I hope you're having a wonderful day, and stay classy out there, people. All right, bye.